Chapter 3 of the South African Law of Persons, 6th edition, by Jacqueline Heaton. The topic of Chapter 3 is status. Under Chapter 3, we have Introduction, 3.2, Legal Capacity, 3.3, Capacity to act, 3.4, Capacity to litigate, 3.5, Capacity to be held accountable for crimes and delicts. Chapter 3 is contained from page 35 to page 37. 3.1 Introduction. In Chapter 1, it was indicated that the law of persons is that part of private law which inter alia determines the legal status of a legal subject. For a proper grasp of the law of persons, it is therefore very important that the meaning of the concept status, in quotes, be understood. The word status, in quotes, is derived from the Latin verb stare, that is to stand, which in itself is a good indication of what is meant by status. Here we are concerned with a person's standing, in quotes, in the law. This standing, in quotes, is determined by all those attributes a person has, or the condition in which he or she finds himself or herself, to which the law attaches consequences. In private law, the most important attributes or factors which determine a person's status are domicile, birth of unmarried parents, youth, physical illness or incapacity, mental illness or incapacity, intoxication, prodigality, and insolvency. These factors are discussed in more detail in the chapters that follow. To properly grasp the concept status, in quotes, and its implications, one has to understand what capacities a legal subject can have. These capacities flow directly from law in the objective sense and are sometimes referred to as competencies. They do not arise as a result of a person's right in respect of legal objects and must be distinguished from the powers that the holder of a right has in respect of the object of the right. For example, an owner is entitled to use, enjoy, and dispose of his or her property. See footnote 2. The most important capacities that are traditionally distinguished are legal capacity, capacity to act, and capacity to litigate. That is, locus standi judicio. In broad outline, these capacities refer to the capacity, firstly, to have rights and duties, that is legal capacity. Secondly, to perform juristic acts by which rights and duties are acquired or disposed of, that is capacity to act. And thirdly, to enforce rights and duties in a lawsuit, that is capacity to litigate or locus standi in judicio. A fourth capacity, namely the capacity to be held accountable for crimes and delicts, has been added. These capacities are discussed in more detail immediately below. 3.2 Legal Capacity. Legal capacity is the capacity to have rights and duties. See footnote 3. All human beings have this capacity irrespective of their personal qualities. Thus, a newborn baby, a mentally ill person, and an insolvent person all have legal capacity. A clear distinction must be drawn between the capacity to have rights and duties and the particular rights and duties that a specific person has at a specific time. There is no difference in the status of two persons merely because one has a large estate and consequently has more rights than the other. There will be a difference in their status only if one can have rights that the other cannot. Children below the age of 7, that is infancies, for example, cannot marry and therefore cannot have the rights that arise from a marriage. They have limited legal capacity, and thus not only their legal capacity but also their status differs from that of persons who may marry. Therefore, although all legal subjects have legal capacity, their legal capacity does not extend equally far. Certain legal subjects cannot have certain rights or duties at all, or cannot have certain rights or duties at a specific moment. This means that the legal capacity of those legal subjects is limited to some extent because there are certain rights that they cannot have. It does not, however, mean that they have no legal capacity whatsoever. They are still capable of having rights and duties, although their legal capacity is limited insofar as they cannot have certain rights and duties. No legal subject can be entirely without legal capacity. It is precisely this fact that characterizes a legal subject. Something that can never have rights and duties is not a legal subject, but may be a legal object. See footnote 4. 3.3 Capacity to act. Capacity to act refers to the capacity to perform valid jurisdiction acts. See footnote 5. A juristic act is a human act to which the law attaches at least some of the consequences desired by the party or parties performing the act. A valid juristic act can therefore be brought about only if the law attaches consequences to a person's declaration of intent. It is clear that entering into legal transactions can have serious implications for the persons concerned, and therefore a person must have achieved a certain level of intellectual development before the law confers capacity to act on him or her. Children below the age of 7 years and mentally ill persons, for example, have no capacity to act in South African law. This does not mean that, legally speaking, these people have no will or cannot give expression to it. It simply means that the law, for their own protection, does not attach any validity to their expression of will. In certain cases, the law attaches consequences to some expressions of will by certain persons, while no consequences are attached to other expressions of will by the same persons. Such people, for example, minors between the ages of 7 and 18 years, have limited capacity to act. The considerations underlying the limitations on their capacity to act may vary. People below 18 years of age, for example, are considered not to have the necessary maturity of judgment and must therefore be protected by the law. 3.4 Capacity to litigate. Capacity to litigate, that is, locus standi in judicio, is the capacity to appear in court as a party to a lawsuit. There usually is a close correlation between capacity to act and capacity to litigate. Some authors, see footnote 6, maintain that everyone has all three of the above-mentioned capacities. They argue that even infantes and mentally ill persons have capacity to act and litigate, although they do not have capacity to act or litigate on their own behalf. Though they cannot perform certain juristic acts at all, for example, marrying or executing a will, there are other acts that can be performed on their behalf. For example, entering into an ordinary commercial contract. In the case of the latter acts, the infantes and mentally ill persons themselves perform the acts because their guardians or curators merely act as their functionaries. What these people actually lack is not capacity to act, but the capacity personally to perform the act. A similar argument is advanced in regarding capacity to litigate. In other words, the person lacks the capacity personally to litigate, but does not altogether lack capacity to litigate. See footnote 7. It is submitted that this approach should not be followed. See footnote 8. 3.5. Capacity to be held accountable for crimes and delicts. The three capacities discussed above do not include a person's capacity to be held accountable for crimes and delicts, that is, wrongdoing, he or she commits. A fourth capacity should therefore be added to the traditional ones, namely accountability, or the capacity to be held accountable for crimes and delicts. See footnote 9. This capacity is to a large extent influenced by a person's age and mental condition, because fault in the form of either intent or negligence is, generally speaking, a requirement for criminal and delictual liability. Consequently, if someone cannot have fault, for example, because he or she is too young or is mentally ill, he or she cannot be held accountable for his or her delicts and crimes. Accountability often coincides with capacity to act and capacity to litigate. To summarize, one can say that a person's status is the aggregate of his or her capacities, and also determines his or her capacities, that is, his or her legal capacity, capacity to act, capacity to litigate, and capacity to be held accountable for crimes and delicts. A person's status, in turn, is dependent upon all his or her attributes or the condition in which the person finds himself or herself, and to which the law attaches consequence.